All rise. All persons having business before the Honorable Associate Judges now residing over the District of Columbia Court of Appeals. Draw near and give your attention. God save the United States in this honorable court. This honorable court is now in session. Please be seated and come to order.
Good morning, everybody. Welcome to the District of Columbia Court of Appeals. I apologize, I'm losing my voice a little bit, but I will do my best to make it through the argument without too much notice of that. We have one case on the argument calendar today, and that's Robert Walker versus United States, number C22CO90. Counsel for appellant, and it's Mr. Fortini. You may proceed when you're ready.
Thank you, Your Honor. Michael Fortini on behalf of the appellant, Robert Walker. And Your Honor, I'd ask to reserve 2 minutes for rebuttal.
Okay.
First, Your Honor, as to the harmless error argument that's made in appellant's brief, I'm going to submit on the record on the brief. So I'm going to focus my presentation today on the cause and prejudice standard that appellees argued in their brief. The first degree murder, and well, first of all, does the court want me to give a brief overview of the facts of this case?
We're familiar with the facts. If you want to give a very brief one, that's fine.
That's all right, Your Honor. So in this case, it's a first degree murder case. A first degree murder instruction was given where the trial court utilized a substantial factor language that's typically found in the urban gun battle instructions, usually second degree murder, but she included it in the first degree murder instruction. Now, with regards to the cause prong, United States v. Parker made it clear that the cause prong is satisfied here because in that case, the Court of Appeals found that a defendant shouldn't have predicted what was going to happen with Barrage. They didn't have the tools to construct this argument based on the Supreme Court case Barrage, and they found that the appellant in Parker wasn't expected to raise that argument in direct. Now, the second issue is the prejudice prong. With regards to aiding and abetting, Robert Walker was not convicted on an aiding and abetting theory. Instead, he was convicted as a principal in this case based on the erroneous substantial factor standard.
Well, why do you say that?
The reason I say that, Your Honor, is in order to convict Robert Walker of first degree murder under an aiding and abetting theory, the government had to prove beyond a reasonable doubt that Robert Walker was aware of the principal's intent to kill. Now, in this case, there's 2 statements that are made by the principal regarding his intent to kill an individual that he got into a confrontation with at a nightclub in Maryland. Now, the first time that happened is after an altercation occurs inside the club. The principal, whose name is Kenny Hinton, or I'm going to refer to him as Kenny, steps out, and the informant in this case, Willie Ormond, is also outside, and he observes Kenny Hinton essentially pacing and saying, "I'm going to kill him, I'm going to kill him." Robert Walker is not outside at the time. The record does not establish Robert Walker was outside. However, he was inside the club. Whether or not he observed the fight, it's not clear based on the record. So he didn't hear that. The second time is after the club closes, essentially these 2 groups of friends go back to Benning Park. One group goes up top, the other group goes down bottom. Now, the up top group, the principal Kenny, as well as Willie Ormond, the informant, go back in one vehicle. Kenny is talking about his frustration and his intent. Robert Walker's not in that vehicle. Robert Walker's coming back.
Let's just put self-reporting of intent aside for a second. Let's say that Mr. Walker never heard anybody say, "I intend to kill him." Tends not to be evidence in most first degree murder cases. Under any theory in which your client was convicted, he walked up with multiple armed people, right? They fired weapons. Why couldn't a jury, really, why wouldn't a jury say they intended to kill just based on the bare facts that they're loaded to the nines and they go up and they unleash gunfire on these people? That doesn't seem like an intent to maim, or like, did anybody say we're going to shoot at their knees? It sure looks like a lot of evidence of intent to kill, independent of hearing somebody say, "I intend to kill them."
So let's break that down. We have evidence that Robert Walker went into this individual Fat's apartment with the co-defendant White, the principal, and then an unidentified fourth individual. Now, that depends on the testimony. The people down bottom who testified at trial said there were only 3 individuals who came down. However, Willie Orman says that there's a fourth. Going into the apartment and then exiting the apartment with the others being armed. I mean, we have the individuals down bottom who armed themselves because the testimony was that's the kind of place that it was. You needed to arm yourself. You had to have a gun on yourself at all time. And that came from Everett Wilkinson, I believe. His nickname is Wallaby. He said that he's the one who armed himself with, I believe, is a 40 caliber semi-automatic handgun. So it's a dangerous place. So the jury needs to consider that. And they heard that testimony. So just going into an apartment with individuals who arm themselves with weapons in a dangerous area, I don't think that's enough for the jury to conclude that he's aware of this individual's intent to go down and kill a specific person. He could have went down there to have a verbal interaction with this.
Counsel,
this individual.
you're arguing 2 readings of the facts here, which, you know, perhaps yours is plausible, but doesn't this tie into the actual prejudice standard? I mean, don't you have to show something more than the possibility that the jury might have found X? Don't you have to show, I mean, it can't just be speculative, right?
That's correct. It has to be more than a mere possibility. And in this case, I don't think that, see, what the court is asking me is to assume a set of facts. And I'm saying the court should assume a different set of facts because that's the set of facts that the jury could have concluded based on the record in this case. Now, another important point is after the shooting after the shooting occurs and these individuals go back up top, the record is clear that Kenny Hinton says he thinks he hit someone. White says that he emptied his gun, and the other 2 individuals, not Walker, say that they emptied their gun. Walker is completely silent. Now, there is evidence that
Well, counsel,
David-
let me draw you back one, because
Sure.
I'm not sure what exactly him not saying anything matters for. But to an earlier point before Judge Deal questioned you, you were saying, I think you were getting to the point where, as you said in your brief, that there's no evidence that Hinton expressed this desire in front of Mr. Walker. But we have at page 460 of the transcript from the April 1 hearing, Orman saying directly that this was said in front of him. How do we discount that?
Sure. So Orman says that in the same line of questioning where he says that the individual is 100 feet away. So government counsel is questioning Orman. He says, okay, who's out there? And then he says, okay, how close is defendant Walker? And I'm paraphrasing here, but I can give a direct citation to the record if it's necessary. But he essentially says Walker's in front of Hinton when he's saying the same things. Juries to infer that means he's saying he's going to kill this individual. Not that he wants to harm him, maim him, have a confrontation with him. He wants to kill him. That's what the government wanted the jury to infer based on that statement. I don't think that's a reasonable inference. That's one point. The second is the fact that the witness who said that Walker was in front of Hinton when he made those statements also had just testified that he was 100 feet away in a vehicle. There's no testimony that Walker got out of that vehicle, went to an area closer to Kenny when he's making those statements, and he heard those statements. Now, there is a record that he went into that apartment and he came out with other individuals who were armed, and there is testimony that he was armed. I take issue with that testimony because it's hearsay that came from a detective who questioned Orman. However, that's not before the court at this point, but I think it's important to make the court aware of that. So if he's not in close proximity to Hinton when he says this, and he's in a vehicle 100 feet away, he's not going to know about the intent. See, that's the thing. Going down with a firearm.
I'm sorry to interrupt, but when I look at the substantial factor instruction that's given in conjunction with the first degree murder instruction, it augments the causation element of first degree murder, the first element in the list. Second element in the list being having specific intent to murder. And then presumably the aiding and abetting instruction also instructs the jurors that they need to find he acted with the same intent. Those don't seem affected by the substantial causation instruction that was erroneous. I mean, that I will give you was erroneously given. So I mean, I don't understand how this instruction relieved the government of its burden of showing that your client also was aware of Hinton's intent to kill or had his own intent to kill and during his conduct. Why do you think it does that?
So The instructions that are given allow for the jury to conclude that Robert Walker went down armed, fired a firearm in defense of himself or another, but he didn't satisfy the self-defense standard because he didn't testify. If he didn't testify, how's the jury going to know that he reasonably?
I'm sorry, just repeat that.
Sure. So
Do you think the instructions given allowed them to, but when it says I'm going to instruct you on causation, which relates to element 1 of first degree premeditated murder, it doesn't suggest that element 2, the specific intent, is being displaced by that substantial causation instruction. I mean, typically what would happen in an urban gun battle case where the instruction was erroneously given would be, well, yeah, the defendant had the intent to kill or to aid and abet somebody who had the intent to kill, but it turns out they didn't do it. Somebody else who was totally unrelated to them actually committed the murder. And that's kind of where the urban gun battle instruction did its work. It said, well, that doesn't matter who actually killed them. So if the facts were something like that, then I could see how this instruction harmed your client. But I don't understand how, on your reading, this substantial causation it's not exactly an urban gun battle instruction, but this is substantial factor instruction that's given in conjunction with the first degree murder instruction never purports to displace the requisite intent. And that's what I'm having a hard time understanding why you think it would relieve the jury of its obligation to find the requisite intent that they're told they have to find,
sure. And let me clarify. The argument that I'm making is if Robert Walker acted in self-defense, he had the requisite intent. However, the self-defense, affirmative defense allows him to avoid being convicted of first degree murder. If he shoots his firearm in defense of himself or another, he has the intent to kill. He's trying to neutralize that target. He could have the requisite intent. However, he could still be a substantial factor in the murder of the decedent in this case without having the intent to injure someone unlawfully. If he's acting in self-defense, that is not an unlawful intent to injure or even kill the individual.
How could the record support that?
The record supports that because we have a self-defense instruction that's given. And we know that Walker didn't make any statements about, emptying his clip or I think I hit someone. He's essentially just going with the group and he's just present at the scene. Now, if he fires his firearm and the jury concludes that he fired that firearm and acted with that intent, then he could have acted in self-defense. But because he didn't testify in this case, the jury's not going to have the necessary record to determine that was a reasonable belief that he or another was in danger of imminent death or serious bodily injury, or that it was reasonable to have that belief. Now,
It was his choice not to testify, right?
it was his choice not, I don't know. I can't make any representation. I didn't represent him at trial, so I can't say whether or not that was his choice. I know it's a constitutional right. However, if he didn't testify if he didn't testify to establish the self-defense, my argument here isn't that jury should have found that he acted.
Was there a voluntary manslaughter instruction that told the jury? I would assume there was an instruction that said, if you find that he acted in self-defense and it was unreasonable, well, then that is a mitigating factor that will take this down from first degree murder to voluntary manslaughter. Well, wasn't the jury told that?
The jury was told that, but without Walker testifying, they're not going to have the necessary elements to satisfy a
Well,
self-defense.
that's not true. The question on sufficiency is whether, the evidence that was presented before the jury, oftentimes without any defense case, was sufficient to satisfy the elements of the offense. And so I haven't seen many cases where the defendant comes in afterwards and says, well, if I had been able to testify, then I would have undermined the sufficiency of the evidence.
So the point here is that Robert Walker could have been convicted as a principal. He was convicted as a principal in this case because of the substantial factor language. Even if he didn't make the necessary showing for self-defense, the jury could have concluded that he took all actions consistent with self-defense, didn't have the requisite intent to aid and abet, and that's why they convicted him as a principal. So I'm not coming before you here today to say that there's some kind of legal error in him not testifying. I'm saying because he didn't testify, that's why the jury didn't come back with a self-defense verdict in this case.
So, I mean, that takes me back to my original question, which is, isn't that pretty, aren't you? I mean, isn't that pretty far-fetched given the actual prejudice standard?
I don't think it's far-fetched, Your Honor. In this case, given the lack of a record to establish that he was aware of the intent, and given the fact that my read of the record, it's entirely reasonable that he would go down with his group of friends, armed to protect himself, and then something happens and he has to fire that firearm in self-defense. And then for whatever reason, he doesn't testify at trial to establish that defense.
Under an aiding and abetting theory, does it even matter? Well, I know the answer is it doesn't matter that he fired the firearm. Why are we so focused on whether he fired a firearm and potential self-defense there?
The reason I'm so focused on that is a question from Judge Deal about how sorry, could you repeat that question?
I'm a little bit confused why we're so focused on the self-defense theory when under the available aiding and abetting theory that there was an instruction on, it doesn't seem to matter whether he fired a firearm or not, that he was armed and went down there and was part of this seems to be enough.
I see that I've run out of time. If I could just respond to that last point. The reason that I'm arguing this point is Judge Deal asked about the first element of intent. And I said, if he fired a firearm in self-defense, the jury could still find that he satisfied the intent element. However, they wouldn't find that he satisfied the self-defense standard in this case due to his lack of testifying.
I have one
Please,
more
please.
question for unrelated. Yeah, I know you said you weren't going to address this point, but it was a question that I had about it on that plain error versus abuse of discretion, et cetera. And I understand that you have come in after counsel who originally wrote the brief. Do you still stand on the point? I guess you say you still stand on that point. It seems to me kind of admitting the potential procedural bar if we were to say that that objection did in fact identify and preserve the issue of the instruction with causation. Well, what's your response to that?
So are you asking me if counsel did preserve that error by objecting, then would the harmless error standard still be essentially in play, or is it just?
I think Judge Howard's question is, part of your argument to get around a procedural default is we had cause. We didn't know how could we have objected because Roy was the law and that was an accurate instruction at the time, which seems to be undermined by the fact that trial counsel in fact said, Roy's wrong. Forget about Roy. Don't give the Roy instruction. So if trial counsel could make the objection, what was stopping appellate counsel from doing it?
Appellate counsel didn't have the Fleming en banc decision to rely upon. Now, and this is,
Neither did trial counsel, but yet trial counsel made the Roy is wrong objection perfectly well.
trial counsel makes a lot of objections to preserve the record. So if there's an intervening change in the law that the client can, avail themselves of that, because a lot of times a change wouldn't be retroactive.
But that's the
Preserving,
same reason appellate counsel does it. I mean, even when claims are foreclosed by binding precedent, appellate counsel often says we're preserving this for future purposes.
again, this isn't an ineffective assistance argument against appellate counsel, but Mr. Walker did attempt to revoke the mandate based on ineffective assistance of of appellate counsel in this case. So could appellate counsel have raised that issue? I just don't think they had the tools to do it. And this court in Parker was clear that Barrage didn't give those tools. There just wasn't a sufficient basis for that argument. And I'll just submit on the arguments in Parker.
Okay, sorry, can I ask one more question? So I might have misunderstood you when you first started, but are you maintaining that if a challenge was sufficiently preserved in the trial court, that on a successive 23-110, a harmless error standard would apply as opposed to actual prejudice or plain error?
I'm being very careful about how I answer this question. I am acknowledging that the case law seems to be clear that the cause prejudice standard is what governs successive 23-110 petitions. This is clearly a successive 23-110 petition. However, to the extent that this court wants to find that harmless error could still apply, that's why I'm submitting on the papers. I haven't prepared a presentation on that. I have no additional information to provide the court on that issue, but I don't want to concede that issue. I'm conceding that the case law is clear that it's caused prejudice. However, I'm still maintaining that argument to the extent the court finds that it's in the interest of justice to change that.
Anything else? All right, thank you, counsel.
you.
We'll still give you a couple minutes for rebuttal. We will now hear from counsel for the United States. Whenever you're ready.
Good morning, your honors, and may it please the court. Michael McGovern on behalf of the United States. The trial court did not abuse its discretion when it denied Mr. Walker's successive 23-110 motion, because Mr. Walker can show neither cause nor actual prejudice to overcome the procedural bar that arose when he did not raise the instructional error he now claims in either his direct appeal or in his first 23-110 motion. I'd like to proceed to prejudice, as that's where my colleague left off. And I think what's important to note here is that Mr. Walker cannot show actual prejudice. And the argument that he advances here is not that the causation issue, which is the instructional error he alleges, that the causation instruction on substantial factor was incorrect.
Do you disagree with that?
No, Your Honor, we don't disagree that in this case, substantial factor does not equate to but-for causation. But his argument is not that he was prejudiced because the jury was not required to find but-for causation, and that's because he cannot, on this record, make that argument. And he can't make that argument because of the special instruction that the trial judge included in this case, which required that for the jury to find first-degree murder, it must find that the bullet that killed the decedent came from one of the up top members. Therefore, under that instruction, the jury must have found either that Mr. Walker's gun killed the decedent, which would be but-for causation, or that it was another one of the members of the crew from up top who killed her.
So
and
counsel,
he was aiding.
sorry. Is your argument a procedural one, which is that counsel is now adopting a different argument than the one that he briefed in his successive 23-110 and on appeal? Or is your argument that counsel can't establish actual prejudice, which is a standard that requires more than just some chance that the jury would have come out differently here?
Yes, it's the latter, Your Honor. It's that counsel can't establish any actual prejudice. His only attempt to do so, as Judge Deal indicated, goes to an element that wasn't at issue with the erroneous instruction. And that is, he now attacks the mens rea issue, whether or not we could show an intent to kill. But the instructional error went to whether or not but-for causation was required. He cannot show that he was prejudiced in but-for causation, and there's no indication that a jury would have changed the mens rea requirements based on an erroneous causation instruction. And so the only argument he has with respect to prejudice doesn't relate to the actual error that was committed. And to the extent that he makes that argument, it's built solely upon a rereading of the evidence and urging this court to take a different view of that evidence, a view that the trial court recognized there was no reasonable possibility that the jury would have, which we, in our brief note, is a lower standard than the actual prejudice standard that applies with respect to a procedural
Well,
law.
what does actual prejudice entail in your view?
Actual prejudice, as the Supreme Court defined it in Frady, requires, they termed it as a significant probability. And this court has recognized that actual prejudice is a higher standard than plain error. The plain error standard is whether or not the plain error prejudice standard is whether or not there's a reasonable possibility of a different result, a reasonable probability of a different result. And here, under Frady, the actual prejudice standard was phrased as a substantial likelihood, which is a higher.
But if you combine the third and fourth prongs of plain error, then where's the delta really practically between that and the actual prejudice standard, at least practically speaking?
I don't know that I can articulate precisely what that delta is, but what I can say is that the Supreme Court recognized in Henderson that actual prejudice is a higher showing. Whatever actual prejudice may be, it is a higher showing than plain error. And the court's decision here rested on plain error, which was the lower prejudice standard. And so we believe under even a plain error standard, we would succeed. The government's position is that it would succeed on a harmless error standard were this court to adopt the arguments that appellant had made in his brief about harmless error. But we believe that the proper standard is actual prejudice, and that the court's analysis of prejudice meets that standard in this case.
Can I ask you about cause quickly?
Yes, Your Honor.
What do we do about Parker? I mean, I realize it didn't, perhaps it's dicta. I don't know exactly if it addressed the question, but it certainly made clear that in that division's view, a defendant couldn't have been able to predict the effect of burrage, however you say it.
I think I take a different reading of Parker than Your Honor, or than appellant does. The Parker decision certainly says that that the Parker defendant could have challenged, but that he need not be expected to, given that it would likely have been foreclosed by the court, that he wouldn't succeed on the merits likely given Roy and the others. So he wouldn't be expected to bring that claim. But the fact that the court acknowledges in Parker that he could have brought the claim is an acknowledgement that there is in fact legal precedent that supports and undermines the Roy decision at the time.
I don't know that's true. And I said the reason why I say that is because Burrage did not purport to be a sea change in the law of causation. I mean, you can tell me if you disagree with that statement, but as I read Burrage, it's saying, these courts, that's a case about substantial factor in contributing to a drug death, a drug overdose, right? And the court says roughly, these courts are confusing what but-for causation and proximate causation is. See these cases from 100 years ago that explain all this, and we're going to reiterate it now. Those cases from 100 years ago were available to Roy as well. And in Roy, we said, we did the thing that we later said, well, we mucked that up a little bit. So I have a hard time understanding. Let me zoom back a little. I take it you agree that a change of the law can sometimes provide somebody with cause for failing to raise an argument in an earlier appeal, so to get over the procedural default hurdles.
Yes, Your Honor.
Can you give me an example of what satisfies your view of like what's unforeseeable enough? I mean, there's always anytime there's a change of the law, you can point to some other cases before it that sort of presaged it. Is that all it takes?
So I think, Your Honor, what I would do is direct Your Honor to the differences between Engel v. Isaac, the United States Supreme Court there, and their decision in Reed versus Ross. In Reed versus Ross, they found indeed the cause standard was met, and that there was a reason to meet the standard for the procedural bar, that they would allow them to overcome that. And it was because the particular change in law that occurred there, which was the Supreme Court deciding that a state court could not allow procedurally a defendant to bear a burden beyond a reasonable doubt to disprove certain defenses. That many states had long-standing traditions where the burden was on the defendant. And prior to the Supreme Court's articulation of that as an incorrect constitutional matter, there was no way for state court defendants to raise this, or no reason for state court defendants to raise this. And so in Reed versus Ross, they find that the long-standing traditions of these states overcame the fact that one could have maybe made a legal argument, but one wouldn't be expected to, and they didn't have the Supreme Court case in their hand to say this is incorrect. But in Engel versus...
Just to pause there, because you kind of paint Burrage as this dagger that should have alerted Mr. Walker to the incorrectness of Roy. After Burrage was decided in the division of Fleming, the panel did not say Roy was wrong. They could have said, if it had been substantially undermined by Burrage, the correct thing for the division to do would have been to say Roy was wrong, Burrage is intervening precedent, and now we have to take a new tack. Instead, the division in Fleming said, forget about Burrage, which the dissent discussed. They said, we've accounted for all that in Roy. That's how I remember it.
So I think my reading is that, or we believe that Fleming and the fact that there was a concurrence by Judge Easterly shows that this claim was legally available. Judge Easterly concurred because she felt bound by Roy previously, but
I don't understand why that wasn't true in Reed v. Ross then. Like, why isn't the fact that a subsequent defendant eventually brought up this argument that he couldn't be forced to prove beyond a reasonable doubt the lack of an affirmative defense? Why isn't that proof positive that the claim was available to the defendant?
Because there was no Supreme Court case, no legal precedent on which to bring that. There wasn't a good faith basis in the legal precedent to pursue that claim. Once Burrage arose,
The claim,
defense counsel.
and yet it eventually won before the Supreme Court. So the principles I'm being asked to support are that was a frivolous and fruitless argument in Reed v. Ross that he just so happened to win before the Supreme Court.
I'm sorry.
I mean, it sounds like you're saying, well, Reed v. Ross, he had no way to anticipate the claim that eventually won before the Supreme Court. So it's kind of like saying, you understand why I'm having a hard time with the concept.
I do, Your Honor, but if I could just perhaps put it this way. What we do know is that at this trial, defense counsel objected to the gun battle instruction and didn't have a case to cite as to why they believed that the court was wrong. And at that time, when they made that objection in 2013, Burrage had not been decided.
I mean, what about, I think it was McKinnon. So in addition to Burrage, Judge Easterly's concurrence cites to like a 1985, I think, opinion called McKinnon that also articulates the same sort of but-for causation standards that Burrage would later articulate. And Burrage itself cites to just, dozens of cases that were decades and decades earlier. But why we had just sort of rejected those in Roy.
Well, I disagree that they rejected them in Roy. I don't believe that the causation issue was teed up to the court in Roy in this manner at all. There's no discussion of but-for causation. They deem the gun battle instruction to be a theory of proximate causation, but the difference between but-for and proximate causation and their intersection is not addressed. Rather, in Roy, you did have a dissenting judge who raised a concern with but-for causation in the context of gun battle, Judge Glickman's dissent in Roy, which says there is some legal issue here. And Burrage puts meat on that and says, yes, substantial factor is not a way to describe but-for causation. And once that comes into play, the tools are available. And really the question here is whether or not a legal claim is reasonably available. Or either the factual or legal basis for a claim is reasonably available. And once the Supreme Court's case in Burrage comes down, defense counsel has the building blocks to construct that claim.
Sorry, please.
How much does your argument depend on the fact that Burrage was a Supreme Court decision? I mean, suppose we had a similar situation with a Kansas Intermediate Appellate Court ruling on but-for causation. Are defendants, especially incarcerated defendants, sort of required to scan those sorts of decisions on a daily basis?
I think that's a much harder case for the government. I think what you would also need to understand is in how many states was this in play? How much is this an issue that is being addressed by the courts? And are there being decisions on either side? So it's looking more at the state of the law generally in this area as to whether there's a decision. So I'm hesitant to say that one intermediate appellate court from a state court that is unrelated to another person's jurisdiction would necessarily mean that an argument was reasonably available. But where the argument, and this maybe goes to Judge Steele's question, where the argument relies on very standard, long-standing traditions of legal argument, such as but-for causation, perhaps it is that although people weren't concentrated, the argument for but-for causation existed. And just because the claim wasn't being brought doesn't preclude a defendant from having brought that claim.
So I think I understand your jurisprudential argument, but let me just try to understand why you think it makes sense, why it makes sense from a perspective of judicial administration to say criminal defendants, all your foreclosed claims, all the ones that we've already said are non-starters with us. if you want to ever raise them, if there's a change in the law, you need to preserve them on appeal. So what we'll end up getting are briefs that say things like, well, if you should ever, if Crawford's ever overturned and it goes back to Ohio versus Roberts, this would be an error. Almendarez Torres, if that's ever overturned and you need to prove a conviction to a jury, well, I want to preserve that as well. Why? Like, that seems like a big waste of everybody's time. I don't want to see more sovereign citizen arguments in my life. I don't want to see more arguments about why the district courts are unconstitutional. I don't want to hear again about Almendarez Torres. Are appellants just putting footnotes of like every pipe dream argument just to make sure that they haven't forfeited it if there's a change in the law? I don't get the purpose of it.
I think, Your Honor, the Supreme Court looks at the procedural bar and the reason that the cause and prejudice standard exists to protect the finality of judgments. Because as we sit here more than a decade after the original trial, were this court to overturn the conviction, all of the parties would return to court and there would have to be a new trial on what occurred more than 10 years ago when the memory of the witnesses is much farther from the events in question. The question of whether everyone would be available is there. And so that finality is a very important factor and that the court wants to consider.
But if Mr. Walker were actually convicted of first-degree murder on a theory that is just incorrect, we've said he in fact is not guilty of that as a matter of substantive law, wouldn't that interest in saying that overcome the interest in finality? I mean, I would think the United States, if they actually thought that to be true, the United States might concede and be willing to go concede that we should vacate the first-degree murder conviction. If we had a special verdict form for the jury and they said, yep, we're convicting him on urban gun battle theory. We don't think the bullet was fired from the down bottom boys. It wasn't them up there, but he's guilty under this theory. And so we're going to convict him. You don't think that's a more powerful concern than the interest in finality of judgments that are erroneous?
I think the question that's presented here was, did he receive a fair trial given the instructions that he received at the time, even though one of those instructions, as we now know, incorrectly described the law? And the cause and prejudice inquiry goes to that question. Was this a fair proceeding that we can stand by? And the answer in this case is yes, because he cannot show either cause, but this court need not reach the cause prong if it determines, as we believe as well, he cannot show actual prejudice.
Can I ask one? Sorry.
Yes,
one
please,
quick
please.
question. You concede in your brief that Fleming is retroactive if the claim is not procedurally barred, right?
Yes.
And my understanding is that we haven't actually said that, this court, with respect to Fleming. I guess my question is, do we need to decide that for purposes of this case?
No, Your Honor, I don't believe that you would need to decide whether or not it would be retroactive because the procedural bar and the inability to overcome it means that this court need not go to the merits of the actual error claim.
And so I guess that's my question. Retroactivity is a merits question.
It would be whether this instruction was erroneous at the time that it was given. And so I believe I would lump that into a merits claim. The prejudice inquiry, even if we assume that it's retroactive, it may be that there's a further argument that it wasn't retroactive and therefore it was not erroneous at all. But even assuming that it would have been error at the time that it was given, there's no prejudice here. And so there's no reason to reach the retroactivity question itself in this particular case.
Thank you, Mr. McGovern.
Thank you.
And Mr. Fortini, we'll give you a few minutes for rebuttal.
Thank you, Your Honor. Counsel for Appellee pointed out that I spent a lot of time focusing on the mens rea here. I'm arguing that the substantial factor language is what led to error, but I'm spending a lot of time on that. The reason I'm spending a lot of time on that is if this court finds that Mr. Walker was convicted under an aiding and abetting theory, then all these arguments don't matter because Fleming is clear that you can still convict under aiding and abetting. So I'm arguing that the aiding and abetting was not the theory the jury convicted him on because they had this vague substantial factor language to rely upon. And then I'm trying to present the record in such a way that the court can understand how the jury would convict Mr. Walker as a principal based on that vague substantial factor language. And Mr. Walker can establish actual prejudice here because if the jury did convict him as a principal based on this substantial factor, whether just based on him being present there or based on him firing in defense of himself or another, he's being convicted for first-degree murder when the government hasn't proved beyond a reasonable doubt all of the necessary elements here. He is certainly being prejudiced by this. The trial court did give an instruction that the jury had to find the fatal bullet was fired by an up top member. However, this didn't cure the substantial factor error because it still gave the jury an avenue to convict Walker as a principal, even if he wasn't the but-for cause. Again, if Kenny fires the fatal shot and Walker ends up firing in self-defense, or he's just present with a firearm there for his own defense, then he could still be convicted here based on substantial factor.
Why? I don't understand why.
The reason why is even if the fatal bullet was fired by Kenny, and I'm not willing to concede that because the firearms expert from the government testified that there could have been over 10 firearms down there. There could have been 2 different revolvers, 2 different bullet fragments were recovered. That firearms expert couldn't even say those 2 bullet fragments came from the same revolver. And it's a 38 or 357 Magnum, which is only fireable by a revolver, not a semi-automatic. That's the bullet that's recovered from the decedent. We have evidence that Hinton had a revolver. However, there's 13 other people down bottom that could have had a revolver.
I mean, if he doesn't hit him and he doesn't aid in a bet because he just shows up and fires back in self-defense, I don't understand how these instructions get you to first-degree murder. I'm just confused by that. I guess your answer is because, I mean, how is he even a substantial factor in the decedent's death if he doesn't hit him and he doesn't aid in a bet? It
goes to this, essentially, what I think happened is, the way I see this, the trial court essentially gave 2 gun battle instructions, a first degree and a second degree. So the jury decides, yeah, he's down there, he participated in the gun battle, or he's present with a firearm while that gun battle is occurring. So we're going to find him as being responsible for this. We're going to convict him as the principal, either because he's firing or he's down there. There's an urban gun battle. He's a substantial factor in that bullet being fired, striking the decedent.
But you're reading out of the first-degree murder instruction, the piece about the shot having had to have come from the up top gang, right?
Right.
I mean, that's the difference.
Right. So given that the jury did convict, we conclude that the jury did make that finding. I'm saying I don't believe that finding was supported by the record, but I can see the jury, based on that instruction, the jury found that that fatal bullet was fired by some up top member. That's clear. However, even if Kenny fires that fatal shot, the jury makes that conclusion. And then again, Robert Walker is there with a firearm, or he's there firing a firearm. Their jury can still find he's a substantial factor here because the jury doesn't know what substantial factor means. There's no defining instruction there. And the court in Parker is clear that substantial factor is significantly lower than but-for, which is required under the DC homicide statutes. And I think this court has already found or will find that first-degree murder is included. You need but-for causation for that.
So your argument is if error could exist, it does exist, as opposed to us saying if error could exist, but a non-erroneous explanation can exist, we should not go that way.
So no, it's not because error could exist, it does. I'm trying to point to specific errors in the record and say because of these specific errors, a jury found that Robert Walker was the principal, convicted him as a principal based on substantial factor. And just to highlight those again, they didn't convict based on aiding and abetting because there's no evidence that he was aware of the principal's intent, Kenny's intent to murder. He doesn't say that he fired any shots when he comes up. He doesn't say that he hit anyone. He's completely quiet. The only testimony that he was armed with a firearm comes from the hearsay testimony of a detective who is essentially giving a hearsay account from the informant here, Willie Ormond. Willie Ormond testified, so the government could have solicited that. That's not an issue for this case. However, I think it's relevant for the court to consider that. And then the fact that he didn't testify, the jury couldn't have sufficient basis to find that he acted in self-defense. So I'm pointing to these specific areas in the record and saying, because of this, a jury convicted him as a principal under substantial factor. It's not that an error could exist, and I'm saying therefore it has to. I believe the error does exist because all the reasons I just articulated.
There are no further questions from my colleagues. All right, thank you, Mr. Pertini.
And just in
Oh,
conclusion,
please, go ahead.
just in conclusion, Robert Walker is asking that this court reverse the trial court's order denying his motion to vacate. Ask that this court vacate his conviction for first-degree murder and then remand for further proceedings. Thank you, Your Honor.
All right, thank you, counsel. The case is under advisement and the court will stand adjourned.